What do you think about that?
Well, it's an unfortunate case. But this is about the third cases of mutiny that I'm aware of. In all the three cases, the authorities never denied the fact that the soldiers involved had a good cause. In the first one, which was defended by the late Chief Gani Fawehinmi, 23 soldiers were injured in Liberia during the civil war in that country. They were brought to Nigeria for treatment, but the hospitals here could not handle them. So they were flown to Egypt, Cairo, for medical attention. While they were there, they suffered greatly because their allowances were not remitted to them. In fact, their allowances were cornered by some officers. So the day they were to be brought back to Nigeria, they turned the airport upside down and even beat up the ambassador of Nigeria. Of course, the military authorities were mad with them. So they were charged with conspiracy, mutiny, and the rest of them. Of course, they were jailed and sentenced to life imprisonment. Was it death? No, life imprisonment. So the late Chief Gani Fawehinmi took up the matter at the Court of Appeal. And the Court of Appeal made it clear to the military authorities that first and foremost, those soldiers were Nigerians. And as citizens of this country, they also have a right to protest. And that since it was admitted that the allowances due to them were diverted, there was no basis to have given them that sort of punishment. For other reasons, the Court of Appeal quashed their conviction and sentence. The second one, I defended that. This has to do with 27 soldiers who were also sentenced to life imprisonment for mutiny in Akure, a few years ago. In that case, again, these soldiers, boys and girls, had served in Liberia. Money paid to them by the United Nations, peacekeeping sector, was diverted and cornered. The officers who cornered the funds were identified, tried, and sentenced to only a reduction in rank, while the victims were sentenced to life imprisonment. Of course, I took this up with the authorities. At the end of the day, the Army Council reviewed their matter, commuted the sentence to 7 years imprisonment, and later pardoned them completely. This one, very unfortunate, because mutiny strikes at the very foundation of discipline in the military. So any country will take the question of mutiny very seriously. But they were wrongly charged under Section 52(1) of the Armed Forces Act. They should have been charged under Section 52(2), which provides for life imprisonment. Because even from the judgment that has just been read, it was an attempted murder. Nobody was killed. So you can't sentence them to death. It could be life imprisonment. But even having regard to the facts and circumstances of the case, whereby these boys were protesting lack of their feeding allowance. I mean, they were not paid their feeding allowances. They had no food. And of course, they had no ammunitions to fight the dreaded Boko Haram sect. So they protested. And unfortunately, on the day they attacked the GOC, some dead bodies, some corpses of their colleagues had just been brought to the barracks. And they all felt there was no basis to have lost those guys if they were properly armed. So it was the visit of the COC coincided, with that, incident. And that was why, they rioted. Of course, the army authorities investigated the case and found that the GOC was at fault, for which reason it was removed and has now been retired. However, I'm convinced that the military authorities, the Army Council, will have to review this case and ensure that justice is done. It has not been done. Judgment has been delivered, but justice has not been done.
So what would justice be here? They should be tried under what, section 52 of the
Well,
Court
like the
Martial
guy who was merely sentenced to 28 days imprisonment, I think the sentences, I mean, I'm of the view that the sentence will have to be commuted. Having regard to the case of the Akure 27 I mentioned, and the Yusuf and the Nigerian army, you know, if this case gets to the Court of Appeal, I'm quite convinced that the soldiers are likely to be discharged and acquitted.
There's one thing you mentioned here. These soldiers have been charged for mutiny, which
Yes.
you say
Yes.
acknowledge it strikes at the heart of discipline within
Yes.
the military. Do you think that it sets a dangerous precedent if, you know, this thing, if it's reviewed in favor of the soldiers?
In the case that I handled, the case of the Akure 27, I advanced the profound argument that those victims should not be punished. Because they were summoned to Akure, 850 soldiers, come from all over the country, come and collect your money. They go to Akure and they were being told stories for 2 weeks. And so they rioted. Because these funds were paid to them by the United Nations, but they were tricked, or they were meant to believe, oh, we need to save the money for you in Nigeria. And they got home, they couldn't get the money. Okay, come to Akure and collect your money. So when the military authorities examined the totality of the facts, they came to the conclusion that these guys, boys and girls, have to be freed. And so they pardoned them. I wanted them reinstated, but I was told that that would have created a dangerous precedent. I also believe that in this case, these soldiers will have to be let off the hook. In order not to create a dangerous precedent, of course, they may be retired prematurely. But to sentence them to death in the circumstances of this case is totally uncalled for.
You know, but one wonders, because first of all, I mean, if you look at the Act and Section 52, which you cited, talking about mutiny, and reading through it, even sometimes you wonder, even the method of it, you could be in trouble.
Yes.
If you look at Section 52B, well, yes, it says incites any other person subject to service law under this act or takes part in the mutiny, whether actual or intended.
Yeah.
And if they signed up for these kind of things, it means that...
No, Section 52(2) is more relevant for this case.
For this?
Yeah.
So that wasn't what...
That one talks of life imprisonment when there is also a mutiny. But this one, nobody was killed. In the Akure case, of course, they were charged with mutiny under Section 52, subsection 1. And I said, no, it's not possible. And they now amended it, you know, to read Section 52(2). You know, since the officer was not killed, fortunately.
Do you think that within the
so you can't sentence them to death?
Within the ranks of the military, should that be a way that soldiers can get their grievances across without being victimized? Because what comes through here is that at some point soldiers get victimized or feel victimized, and they think they have no other way to show their displeasure than to...
No, there are two issues there in the military. Again, this is part of the colonial legacy. You cannot complain. If you complain, it's seen as even an offense, sir. You are inciting mutiny. So, head or tail, you are bound to lose. And so when young people in the military are therefore forced to engage in violence or whatever, which is not good, but you also must consider the fact that you have pushed them. Because in the Akure case, I made it clear, 4 times now. Those who went to Sudan, those who went to Sierra Leone, those who went to Liberia, their money was stolen.
That is why I think this question will pop
So when
up.
must you continue?
Just,
the second one.
Please tie this question in, because now you've counted four incidents.
Instances.
And well, he wants to know if the military doesn't have laws as it regards orders, superiors handing down to their subordinates, especially when you have a grievance. How do you complain as a military officer? Are there laws to your knowledge?
Well, not quite, but within the military tradition, there are ways of lodging complaints. But generally, soldiers are afraid to lodge complaint because they are usually stigmatized. You are you know, you are marked down. But what we therefore do when we get some of this information of injustice or denial of allowances, we take them up for and on behalf of such soldiers. We're handling a number of cases now of those who were even retired either prematurely or who were denied their allowances. So we're taking them up. It's difficult for them to do so themselves. The other one is about military trial. Again, we have found that we need to have a judge from outside to preside over court martials. Because, I mean, if you ask somebody to try a murder case who is not a lawyer, who is not very familiar.
But they are military lawyers.
No, some of them, some of those who handle these cases are not lawyers. You have a judge advocate who is a lawyer. Again, it's a junior officer who gives advice to his superiors. Now, these military officers who are the judges in the court martial, well, are not bound to take his advice. So there are problems with that.
Okay, that's where we'll have to let it go here today. We thank you for coming on. Mr. Femi Falana, SAN, is also a legal practitioner and human rights activist. Again, thank you for coming on this morning.
Thank you very much. It's my pleasure.
We'll be back. We've got another matter coming up today on the program, so please join us again.